I'm Katrina Vanden Heuvel. As a journalist and commentator, I've written and spoken often about the Supreme Court. Over the years, I've learned that the court's cases are not just about dry legal issues. They're really about the lives of everyday people and about the future of our country. Over the past century, the American people have fought and won important battles in the quest for a fairer and more just society. But something has changed. In case after case, a solid 5-vote conservative majority on the Supreme Court has begun to tip the balance toward corporate interests. This is the story of one of those cases.
There's been a history of the Supreme Court making it much more difficult for individuals to have access to justice.
Another recent Supreme Court decision, PLIVA versus Mensing, is also preventing everyday Americans from having their day in court. The case was about whether the manufacturers of generic drugs can be held liable under state law for failing to adequately warn consumers of health risks. It was brought by Gladys Mensing, who developed severe neurological problems after taking the generic version of the anti-nausea medication Reglan. She sued the generic drug manufacturer, PLIVA, for failing to warn about those health risks. At issue is the fact that state laws require generic drug companies to warn consumers of dangerous side effects, but federal law requires the warning labels on generics to exactly match the brand name drug, even if they later become aware that the drug may be dangerous.
In the PLIVA case, the Supreme Court ruled that federal law overrides these state laws. Federal law now says, no, the generic company has no responsibility if their drug has injured a consumer. And it's a very, very serious problem.
Although the PLIVA case was about Reglan, its impact extends to anyone who takes any generic drug.
I mean, I know now that I took the generic version, but at that point it was just whatever the pharmacy gave me. I didn't have a choice.
Camille Baruch, a Maryland high school student, was prescribed the generic form of Accutane for acne when she was in middle school.
The biggest thing they stressed was to not get pregnant. They didn't mention anything else about any of the other side effects.
But she developed severe gastrointestinal problems.
She was in so much pain. It was so difficult to be around her. She was crying all the time.
Camille was diagnosed with ulcerative colitis.
The symptoms kept getting worse, and by the next year, I was at a point where they couldn't control the symptoms, and their only choice was to do surgery.
These are Cammie's medical records. 1, 2, 8.
They did a total colectomy because by that point, the disease had spread through my whole large intestine, so they took out my whole large intestine.
We had a lot of hope that that was going to be the end of our problems. After the first surgery came and went, and then the second, the third, and as it ended up, Cammie had every complication in the book. This is 5 years worth of records.
In less than 2 years, I had 6 surgeries. This one is for spasms.
And she must still take an array of medications.
These are antibiotics.
This kid went through hell, and she's lost. I mean, she lost a lot of her identity, but she lost, her space in life.
The Baruchs learned there was a suspected connection between Accutane and colitis.
The attorneys that we talked to thought that this was an extremely compelling case, everything that she's gone through.
But then came the PLIVA decision.
I read that decision and I was struck by the fact that in a 5-4 decision of the Supreme Court, the one thing they all agreed on, it leads to absurd consequences. And I could not agree more that that's exactly what it leads to.
In a previous ruling, the Supreme Court had decided that consumers harmed by a brand name drug can sue the manufacturer.
You have the case where there are brand name drugs, the same injury that happened to my daughter. If she had taken brand name Accutane, she would be settled and set up for the lifetime of costs she's going to face as a result of this illness.
Any of the 70% of drugs that are prescribed in the US, which are generic drugs, you now have no ability to have recourse.
A student at Harvard, Gabriel Drapos, also took a generic form of Accutane when he was in high school. Gabe was also diagnosed with ulcerative colitis. He too tried medications with no success and had to have his large intestine removed. He contacted a lawyer.
And he said that he thought it was a clear-cut case.
Again, until the PLIVA decision.
And we spoke again, and he said that as a result of PLIVA v. Mensing, that he wouldn't be able to represent me in this trial, that I couldn't basically have my day in court.
I mean, it hurts me by the fact knowing that no one is going to be held responsible for this, that I'm 18 and my life has been shattered and I have to rebuild my whole life. But knowing that other people are getting sick from it is just as bad.
Are injured, they go see a lawyer, and when the lawyer asks them, well, was this a generic version? And when the answer comes yes, and the lawyer says, well, then I'm sorry, you don't have a case, they will be disappointed to learn that the Supreme Court took away their rights.
The 1% court has ruled, but it should not have the final word. With a renewed spirit of activism, balance can be restored to the American system of justice. Make the fight for fairness in the courts an issue wherever and whenever you can, in your local media, in town meetings, in community gatherings, through social media, and in political campaigns. And visit unequaljustice.org to find out how you can make a difference. With your help, unequal justice can become equal justice once again.